The law draws borders, titles land, and decides who may stay. But the grape answers only to sun, soil, and time. Across Africa, these two forces, law and nature, are colliding. Because vineyards are not planted for a season, they planted for generations. And when the rules that govern land begin to shift, the consequences are not abstract. They shape investment, they shape ownership, they shape whether agriculture can plan for the future. I'm Untatile, and this is The Gavel and the Grape. This is the podcast where we treat the statute book as seriously as the tasting note. We're not just talking about terroir or tannins, we're exploring the policies, the politics, and the legal frameworks that determine who owns the land, who gains access to opportunity, and whose agriculture survives the future. Because once land becomes law, it becomes more than soil, it becomes structure. Let's decant the law behind the label. On today's docket, the land question. First, we open the case file on South Africa, where the recently enacted Expropriation Act 13 of 2024 is testing the constitutional balance between property rights and the debate around compensation. Then, we turn outward. We examine Zimbabwe and Morocco, two very different legal experiments in post-colonial land reform. We'll look at how the disappearance of bankable tenure affected the vineyards of Marondera, contrasted with the long-term state leasing models used in the foothills of the Atlas Mountains. And finally, in our verdict vintage, we'll pour a wine from Bosman family vineyards, an estate that captures transformation not as a sudden decree, but as a deliberate legal design. So pour yourself a glass and let's decant the law behind the label. There's a quiet truth about agriculture. Land is infrastructure for time. Vines take years to establish, sometimes decades to reach their full expression, which means farming is always a wager on the future. And the wager only works if the law gives farmers something precious: time. Because land law doesn't just allocate ownership, it determines whether a farmer can plant a vineyard today and still expect to harvest it 10 years from now. In South Africa, land law sits at the center of the country's constitutional identity. Section 25 of the Constitution protects property rights, but it also mandates land reform. For decades, this tension has been managed through the principle of just and equitable compensation when land is expropriated. But the legal landscape shifted with the enactment of the Expropriation Act 13 of 2024. The Act identifies limited circumstances where compensation may be nil, such as an abandoned land or land held purely for speculation. Supporters argue this provides an essential tool to accelerate land reform. Critics warn that it may undermine the predictability that agricultural investment depends on. Vineyards are the ultimate test for this debate. They are capital intensive, they require long-term finance, and they operate on biological timelines that no legislature can accelerate. A vineyard planted today may only begin producing commercially after 4 years. Full maturity can take 15, which means agriculture relies on something more fragile than capital. It relies on legal certainty over time. When land law becomes unpredictable, finance retreats. But the status quo is also unstable. 3 decades after democracy, land ownership remains deeply unequal. South Africa's challenge is not choosing between justice and stability, it is designing a legal framework capable of delivering both. To understand the cost of legal uncertainty, we turn first to Zimbabwe. In the 1990s, Zimbabwe had a small but respected viticulture sector. Estates like Bushman Rock in Marondera, along with the early plantings at Mukuyu, were proving that the Highveld could produce elegant, export-quality wines. But the fast-track land reform program fundamentally altered the legal foundation beneath those vineyards. Freehold titles were replaced with short-term state permits, and without bankable tenure, the financial logic of long-term farming collapsed. Vines cannot be replanted every political cycle. They require stability, measured in decades. Without that stability, investment disappeared. And with it, much of Zimbabwe's young wine industry faded. not for lack of skill, but for a lack of a predictable legal horizon. Now consider Morocco. Morocco faced the same post-colonial question: who should own the land? But rather than dismantle commercial agriculture, Morocco restructured it. Through long-term usufruct leases, the state retained ownership of the land itself, while investors received secure rights to farm it for 40 to 99 years. In other words, the state kept the soil, producers secured the vine. That legal stability allowed Morocco's wine industry to survive and modernize. Estates like Domaine de la Zouina and Chateau Rosaline produce internationally recognized wines. The lesson from this comparative poll is simple. Zimbabwe disrupted the ownership and tenure. Morocco restructured ownership while protecting tenure. Only one preserved the industry. Land law determines the horizon. Justice without continuity collapses. Continuity without justice stagnates. South Africa's new Expropriation Act 13 of 2024 is an attempt to accelerate land reform. But for it to succeed, it must act as a bridge, not a cliff. Because you cannot rush a vine, and you cannot farm without a legal horizon that extends beyond the next election cycle. And now the verdict vintage. If today's case asks how transformation can occur without destroying continuity, the judgment in the glass is Bosman Family Vineyards Optenhorst Chenin Blanc. These grapes come from some of the oldest Chenin vines in South Africa. But the real structure behind the wine is legal. In 2009, the Bosman family executed one of the largest ownership transformations in the industry, transferring 26% of the business to the Adama Apollo Trust, representing more than 260 permanent workers. Not through sudden redistribution, but through equity, through contracts, through time. Tasting it, bright citrus and quince lead the nose. The palate carries yellow apple, honeyed stone fruit, and a firm mineral backstone that holds through a long, composed finish. It is wine built for patience, which makes it a fitting judgment for today's case, because transformation, like viticulture, cannot be rushed. And when the law works well, it does not simply redistribute land, it redistributes the right to wait for the harvest. Thank you for joining me on the Gavel and the Grape. If today's episode added value, please subscribe and follow us on YouTube, Spotify, and Apple Podcasts. Full show notes and a breakdown of Expropriation Act 13 of 2024 are available in the description. In our next episode, BEE versus local content, where we unpack economic empowerment law and the fight over who truly owns African industry. Until next time, always remember to decant the law behind the label.